All right. So, well, good afternoon, everybody. I'm glad you all could show up. I will try not to ask too many questions and put you on the spot, but I know Paul knows the answers, and so we will go from there. Let's see. Ms. Jefferson, I will try not to call on you too much, but if you do know something, please feel free to jump in. All right, and now Dr. Atkins Brady is here. Let me let her in. So, all right. So, you might say, well, isn't Constitution Day the opportunity for us to learn about the Constitution? And that's absolutely right. And as I was thinking about it, some things happened this past weekend, which caused me to decide to do this on the Fourth Amendment. I'm getting, all right. Sorry, I was getting a chat message. But anyways, so I'm going to give you a little bit of history, but I'm not a history instructor. And so I decided to do it on the Fourth Amendment because I think that we don't realize it, but about half of what I teach in constitutional law revolves around the Fourth Amendment. There's the other amendments, the First Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment, and those amendments are also there, but it's predominantly the Fourth Amendment, because the Fourth Amendment deals with search and seizures and things like that, and that means arrests. It can do with you being patted down or searched. So we're going to talk about that. So I had some events this weekend. I worked, for those of you who don't know it, I am a police officer in Edenton, North Carolina, and I worked there. And I was struck because I had several people I had to detain or arrest, and the first thing everybody says to you as a police officer is, "I know my rights. You're violating my rights." So that's why I said, you know what, I'm going to talk about the Fourth Amendment for Constitution Day, because it's something that's near and dear to me. It's something I have been put in practice on the street for many, many, many years, and it's kind of misunderstood. So what does the Fourth Amendment say? It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, if we break that down, persons, what does that mean? Anybody can jump in and tell me what that means if they like. If you don't, I'll tell you. Anybody? All right, guess it's on me. I'm gonna move this over here out of my way. All right, so what does it mean, your person? It means to be free from being arrested, detained, held, questioned. That's what your person is. The things that you carry in your pocket. What do we all have in our pockets most of the time, or in our purses, right? One of these little things. And this is protected by the Fourth Amendment, and we don't think about that because in the 18th century were these even invented? No, they didn't even know what these were. Didn't know how we would eventually get to that. So, but that's your person. The things that you carry on your person are protected by the Fourth Amendment. What about your houses? I happen to be in my house right now. My house, as Blackstone once said, a man's house, no matter how modest, is his castle. Now, remember, he was talking in the 1700s, 1700s. So he was he referred to a man's castle, but we know that pertains to women now as well. But your castle, your home is your castle. That is your place. That is, and the Constitution recognizes that and protects your house. Your papers. What are your papers? Well, I would submit that papers covers this little thing here. Don't you think? Y'all know what this is, right? This is a thumb drive. But I have documents on here, and these papers are protected just as well as these papers are that I have over here on my desk. So those papers, now remember, when the Fourth Amendment was written, we didn't have these handy dandy devices, did we? Nope, we had papers. But we've expanded and that's what the beautiful thing about the Constitution is, it does expand to fit what we're currently doing. So the Fourth Amendment protects this. This is, these are under the papers or effects. These are the things that we carry around. The police can't stop me, find this in my car, and without a warrant or consent or probable cause, plug it into a computer and see what's on it. And I would submit to you that if you're perfectly honest, there's some silly pictures. There's a picture of my granddaughter on mine, but I probably have 10,000 pictures of my cats doing silly cat stuff that I'd be embarrassed if somebody looked at my phone and saw. But they're your things, and that's what the Fourth Amendment is about. And you can't get a warrant as a police officer without probable cause. Well, guess what? Probable cause isn't defined in here, but we'll talk about it. Because again, this is something that I enjoy. This is something I have used most of my adult life since I made my first arrest in 1983, 40 years ago almost. I've used these things and practiced them. So there's some exceptions, and we'll talk about that. But that's why I wanted to talk about the Fourth Amendment, because it's in our life, and we don't even realize it. When you get pulled over for speeding, if you get pulled over for running a stop sign or a traffic violation, it immediately implicates the Fourth Amendment, because the officer has to have reasonable suspicion, which I'll talk about in a little bit, to even make a traffic stop. They can't just randomly stop vehicles driving down the road and pull them over because they feel like it, or because they have a hunch that something might be amiss. Questions, comments, complaints? I always say that, I'm sorry. Questions or comments? All right.
Mr. DeStefano?
Go ahead, Dr.
No, go ahead,
Mr. I'll let y'all figure out who goes first.
Dr. Tara goes first.
That's what I thought.
Okay, my question was, what about, and I apologize, I can't remember now the exact words you used, but can't pull you over or stop your
randomly stop you.
Randomly stop. So is a DUI checkpoint not considered a random stop? I do remember a time in the community I grew up in where officers would route random cars over into a parking lot and ask you some questions and then let you go on.
That is an excellent question. And what the Supreme Court has said and this is where you get to see that I actually do know this stuff, because I'm not referencing it, but it's the Department of State Police in Michigan were sued over DUI checkpoints back in the 80s. And the Supreme Court upheld it, and it's still the law of the land, is a DUI checkpoint is a minimal intrusion, and that there's an overriding government interest in deterring and detecting drunk drivers. So because of the minimal intrusion, you're not pulled over, you drive through a checkpoint, and basically, having run these checkpoints and been on many of them, we talk to you for a minute and see if there's any reasonable suspicion or probable cause to believe that you might be under the influence. Normally what we first thing we do is we smell alcohol, but it's a minimal intrusion. It's just how you doing tonight, where you heading to, may I see your driver's license? And what I love is if you say, well, I left my driver's license at home, now I have a traffic violation to pull you over to the side and investigate further. Do you see how that works? And it sounds like we're pushing the system, but we're not, because if you pull up to the checkpoint, first thing you say to me is, oh, I'm sorry, I left my driver's license at home. Well, now I have a traffic violation, so I can pull you to the side for that. But what the Supreme Court said is it's a minimal intrusion and there's an overriding government interest. Interestingly, along the same line, they had a hit and run accident that occurred in New York State. I don't remember the case off the top of my head, but it's one that we frequently talk about on random checks. And they said, hey, we're going to look for this car. So we're going to go. And during the times that this hit and run where this person was killed took place, we're going to hand out flyers asking people for information. And there was so there's a stop involved. And basically they would say, hey, do you come through here every day about this time because we had an accident, somebody was killed, and if you hear, think of anything or you saw anything, please call us. Well, it turns out that somebody approaching that particular event was wanted and had drugs in his car. So he made an illegal U-turn. A police officer stopped and found it, and they said, well, the stop was illegal, but along the same line, the Supreme Court said they were looking for a particular crime and it was a minimal intrusion. They weren't stopping everybody and taking them out of the vehicle. They were simply saying, hey, if you come through here all the time, if you have any information on this hit and run, please contact us. So that's how they balance that is the minimal intrusion based on the government need for information. Does that make sense, Dr. Atkins-Brady?
It does. Thank you for answering the question. Can I ask a follow-up?
Sure.
So are there other things that we might encounter in our daily life that would be considered minimal intrusion?
Yeah, sure. Absolutely.
What would some examples be?
I'll give you an example. We have a policy at the department. If it's a day shift in Edenton or Chowan County, officers can set up a checkpoint as long as it's run or monitored by a supervisor, and it's called a driver's license checkpoint. And we can go somewhere in the town or the county and set up two officers, and we can, as you pull up, ask to see your driver's license. And what did I say? If you say, sorry, I left my driver's license at home, all right, pull over here and we'll have a longer conversation about what's going on. If you hand me your driver's license, I look at it, there's no indication anything's out of the way, I hand you your driver's license and tell you have a nice day and you drive away. But the rule that the Supreme Court fashioned on that one is I can't, as a police officer, just do it. I have to have a supervisor approve it. So we call them on the radio and say, hey, we'd like to set up a driver's license checkpoint unless we get, some calls or get busy. Is that okay? And the supervisor says, yeah, that's fine. So you might run into that as a minimal intrusion. And as long as you stop every vehicle or every fifth vehicle or whatever the criteria is, it's considered okay, because it's not a true traffic stop. It's just a, hey, can I see your driver's license? Okay, have a nice day. But when you say, I don't have it, now it might be that you just left your wallet or your purse at home, and that's fine. But it also might be that it's revoked or suspended, which those people, we don't want them to be driving, right?
Right.
So does that answer your question?
Yeah.
So you can encounter things like that.
Okay.
All right. Paul, did you have a question?
Well, you kind of touched on it, but I'm wondering how probable cause affects something. For example, if you have probable cause to suspect that I have committed a traffic violation and you stop me to investigate whether I have in fact committed a traffic violation, do you then have to have separate probable cause before you could search my vehicle for something else?
Good question. And I will tell you, Paul, you are making a mistake that even lawyers make. I don't need probable cause to stop your vehicle for a traffic violation. I just need what's called reasonable articulable suspicion. And we have that on a slide here. Hang on, let me see. I'm jumping ahead, but we'll come back. All right. There's two things that you touched on. Probable cause is facts and circumstances which would lead a reasonable person to believe that a crime is being committed, has been committed, or is about to be committed. That's probable cause. And then reasonable suspicion is facts and circumstances which would lead a similarly experienced and trained police officer to believe that a crime is being committed, has been committed, or is about to be committed. So let me talk about probable cause. Probable cause is a reasonable person standard. All right, so that's people like Ms. Jefferson, Dr. Atkins-Brady, and yourself, Paul. People who are not law enforcement officers, but who can look at something and say, yeah, I think there's something going on here. And reasonable suspicion is something that police officers are uniquely positioned to identify. For example, I've attended many schools on observing narcotics transactions between individuals. So I have that particularized training to say, yeah, that meets the criteria. That looks like a drug deal going on right there. To the average person, that might look like a guy who just walks up to the car and they have a conversation and then he walks away. But we watch particularly for the hand movements and how the hands are being held as they're walking away. Because if they're holding money, they'll have a clenched look rather than the normal way a hand is carried. So just things like that. So that's the difference between probable cause and reasonable suspicion. So I stop you because I have reasonable suspicion to believe that you ran a stop sign, okay? So I've got to admit somebody, so give me just 1 second. All right, so I pull you over, and now I'm having a conversation with you about running the stop sign. And I start to detect odors, I start to detect, or I see things in the car, that can give me probable cause for a search. So, for example, when I walk up to the car, and now I want to be careful here because Virginia just changed the law. The odor of alcohol, marijuana coming from a vehicle is no longer probable cause to search that vehicle in Virginia. Now, where I work in North Carolina, I can still do it, but I can't here because the state has passed a general statute that says you can't do it anymore. So, but what if I walk up to the car and, Paul, I start to notice from your mannerisms that you're slurring your words, your eyes are bloodshot and watery, and there's a strong odor of an alcoholic beverage coming from the vehicle, right? Now, what am I forming? I think Miss Jefferson or Miss Williams could probably say he might be drunk, and might not be that he shouldn't be driving a car. So that's what probable cause is. The ordinary person, the average person can look at it and say, yeah, I think something might be going on here. So that's the difference between reasonable suspicion and probable cause. Does that explain it, Paul?
It does.
It does. Okay. So we did jump ahead a little bit, but that's so. And once you do develop probable cause, then you can make an arrest. An important note to make is the Supreme Court has said, because think about this: you get pulled over for speeding, or what's the question that a lot of police officers ask when they stop you?
Do you know why I stopped you?
Now, that would seem to violate your right against self-incrimination, wouldn't it? Think about it. Because you're in custody, right? Police officer stops you, walks up, and says, hey, do you know why I stopped you? Or which I've used sometimes is, you know how fast you were going? And a lot of people will say, well, wait a minute, you haven't advised me of Miranda. I don't have to answer those questions because I'm incriminating myself, right? You say, yeah, you stopped me because I rolled through the stop sign back there. Well, that's good, can be used against you. But what the courts have said is that a traffic stop, a regular, ordinary traffic stop, doesn't invoke Miranda. It doesn't require that I advise you of your rights, because everybody knows if you ran a stop sign and you're not wanted and you don't have drugs in the car, what's going to happen to you? At the very worst, you're going to sign a ticket and I'm going to give you your stuff back and tell you to drive carefully and let you go, right? So that's what the Supreme Court said. That is not a detention that requires Miranda. So we can walk up and say, hey, do you know why I stopped you? Well, yeah, I rolled through the stop sign back there at the intersection. Yeah, you did. That's why I stopped you. So need your license and registration at this point. Does that make sense? That but traffic stops are not based on probable cause or full-blown arrest. Normally, just like the Supreme Court said, you get a ticket, you sign it, and you go on your way. And you're done. Any other questions about that? I appreciate this because I was hoping that there would be some questions about it. Let's go back a little bit. And I'll get back to my order of presentation. Because I was going to give you some, I just want you to remember too. So we're protecting your persons, houses, papers, and effects. But it has to be, if you look at that bottom sentence, the person must have an expectation of privacy And the expectation must be one that the society is willing to recognize. All right, as a private place. All right, I'm in my office at my house right now, and no argument that it's not a private place, right? But Paul, I think you're in your office at work right now.
I am.
Dr. Atkins Brady, is that his private place? No. No, there may be things that are private. You may have a briefcase that belongs to you that was not issued by the college. That would be something that we as a society would say, oh, that's a private place. The pockets on your pants are probably a private place. Dr. Atkins Brady, I bet you have a purse in your office, don't you? Or something you carry your paperwork. That is a private place. But those cabinets behind you are not yours. They are not your private property. They belong to the college, and they are subject to search within reason. It can't be done to harass or anything like that. But if there is reason to believe that you're doing something illegal out of those cabinets, the college can consent to a search of those cabinets. Does that make sense? So when we say a reasonable expectation of privacy, how about this one? All right, I threw my trash in the trash can in my backyard. Is that do I have a reasonable expectation of privacy that in my backyard right now, that nobody will go in there and start digging through my papers? What do you think? No? Now remember, it's in my backyard on my property, so I'm giving you a hint that it might be yes. Yeah, the courts have said that my trash in my trash can in my backyard, and I'm pointing to my backyard like you all know where it is, but my front yard is this way.
Of course, it's over there.
Yeah, my front yard is this way, my backyard is this way. But my trash in the back I do have a reasonable expectation of privacy. Now, once I wheel it around, because trash day is on Tuesday here, on Monday night, when I wheel it around to the front and park it on the street, I have lost that expectation of privacy. Wouldn't you agree? I've kind of abandoned it. So abandoned property is not subject to an expectation of privacy. Make sense? That's how complicated it can get. And again, I've done searches where we wait for the person to put their trash out because we suspect that they're doing something illegal in their home, and we may find evidence in the trash can, and without a warrant, we go and search. Now, if you get a search warrant, you can come and search my trash can in the backyard here. But without a warrant, you got to wait till I park it on the street. Any other questions about expectation?
But
How about this,
from
Paul? Oh, go ahead,
From this
Paul.
language, we would need to explain not just that we wanted to search your trash, but what we expected to find within it.
Right. Only if you were searching it in the backyard.
Mhm.
And then you could get a warrant.
But the warrant would have to not just say that I wanted to search your trash.
Right, that we
but
believe we would find
what I
evidence.
was expecting to find in the trash.
Right, we would find evidence of illegal drug packaging or something. Like a common thing that we used to look for is, the plastic baggies.
Mhm.
When they would manufacture marijuana, not back when I was a teenager and I heard that the bags were really big, but when they would snip the corner of a sandwich bag. They would snip the two corners and then put the marijuana in that, twist it up and sell it like that. And that was evidence. And I seized that kind of stuff out of the trash can. So if you thought I was packaging illegal drugs here at my house, you could get a search warrant to look specifically for packaging material, paraphernalia, effects, drugs themselves. But those snipped corners, because I remember finding those snipped corners and looking at it at first and going, the heck is this? And the drug officer I was with said, oh, take that, that's evidence, because they snipped the corners off the package of the marijuana. So that's what we mean. So so you're right. If you're going to come into the house or the backyard, what we call the curtilage. And if you want to know what curtilage is, you can Google it, or you can take ADJ 227. You'll learn about curtilage. In fact, you'll see a picture of my house, because that's what I use as my yard to say, where's my curtilage? But if you want to come onto the curtilage is basically, how some people own acres and acres of land. If you all of that land, the woods where the deer and the antelope play and everything, that is your property, but there's not a reasonable expectation of privacy in those acres that are miles from your home or very far from your home. But where you have your house, I have a friend who owns several thousand acres down in North Carolina, but where his house is, his shed, his pool, his vehicles are parked, that's called the curtilage. That's where he normally lives on his property. And there is a reasonable expectation of privacy that society is willing to recognize. But where he's got property where we actually go onto a range and shoot, he has people go back there all the time and trespass on his range. And it's just a tough sell that I have a reasonable expectation of privacy, a mile and a half from my home where I can't even see it without driving through the woods. Make sense? Questions? Okay. Sorry, I keep switching screens, and if I'm not on the right screen, it won't switch over on me. All right. So when we were thinking about becoming a country and forming a country, and we were working on the Constitution, there were Federalists. They include George Washington and James Madison. And then there were some anti-Federalists, including Patrick Henry and George Mason. The Federalists favored a strong central government, and the anti-Federalists favored state or individual rights. We still hear that fight sometime today. Where do you think we've kind of landed? Anybody? We have a strong central government and strong states' rights. The federal government controls just about everything, right? Right? Really, they do. On December 15th, 1791, the Bill of Rights was ratified by the states and became law. So basically what happened, and the Fourth Amendment is one of those, the first 10 amendments to the Constitution were inserted because the anti-Federalist would not approve the Constitution unless it had some protections for individuals and states' rights. So they wanted these inserted into the Constitution. And in 1791 they were, so everybody's happy. And we have what we have today, which is the protections of the Bill of Rights. Did you know that the Third Amendment, soldiers can't be quartered in your house during peacetime? Did you know that? Under the Third Amendment? Yeah, that's an important one because that happens every day. But in 1791, it was a real possibility that if you lived in an outer area, they might say, hey, we need to put some soldiers at your house and you need to feed them and give them a place to sleep. And they would do this during peacetime, and we didn't like that. Well, the British government would do that, and we didn't like it, so we put it in our Constitution and said, yeah, you can't do it during peacetime. But if there's a war out here, and I don't know in 1791 off the top of my head how far we had gotten, but let's say we'd gotten to the Mississippi. If there was a war out there with the Indians or the French or whoever it was we were fighting back then, and wasn't there a time that we fought both of them at the same time? And they needed a place to put soldiers, they would stick them in your house and say, okay, feed them and take care of them. So, but those are the things that were inserted and why they were inserted. Questions? All right. So, and this is another interesting point that unless you take my class or another similar class, you won't know. The Fourth Amendment only restricted the actions of the federal government originally. Did you all know that? Did everybody know that? That it only restricted what the federal government could do. It didn't apply to the states. Why? Because the Bill of Rights was inserted to protect us against a strong federal government. We didn't care what the states did because, the states and the people were one, right? There have actually been amendments since that said that, and they had to do with civil rights. But remember, in 1791, I was a resident of Virginia. I was a citizen of Virginia more than I was a citizen of the United States. I was a Virginian. Now that's changed over time, but you have to remember when this was written. So the Fourth Amendment has been extended to the states through incorporation under the 14th Amendment. We had the 14th Amendment, which was passed around the time of the Civil War, after the Civil War, to protect newly freed slaves in the United States. And it basically said, before you're a Virginian, before you're from Connecticut, before you're from Kentucky, everybody living in the United States is a citizen of the United States. So it changed that power dynamic between the federal government and the states. So what we had before then was we would have seizures made, where the states would do something that violated the Fourth Amendment in the way of a seizure, and then they would give that evidence to the federal government, and the federal government said, we didn't do it, the states did it, and it's not covered by the Fourth Amendment. And then you'll see later on a later slide, we eventually said that wasn't okay. The United States said, yeah, you're not going to do that anymore. All right, I already covered this one, so I'm going to jump past this slide. All right, so here's some things, and you'll notice most of these cases, these early cases, occurred in the 60s. So 1960, it held that the silver platter doctrine violated the Fourth Amendment. So they used the 14th Amendment to say, hey, the Fourth Amendment applies to the states as well. So you can't go get evidence. In 1961, they strengthened that. Mapp v. Ohio, one of the most egregious cases if you're familiar with constitutional law. Now Mapp probably had some ties to some shady characters. Okay, we'll say that. And the police went to her house because they suspected that she was making bombs. And when they burst in the door, she asked to see the warrant. They held up a piece of paper like this. They went, here it is. And she grabbed it, and there was a tussle that ensued. They rescued the warrant, handcuffed her. They didn't find any bomb making material, but they searched her house looking for bomb making material, and they found pornographic material. So they charged her and they convicted her. And the US Supreme Court used that case because it originated in the state where the Fourth Amendment was kind of iffy whether it applied or not. And they said, this case shocks the conscience. All right, because it was an egregious overreach by the police. They didn't even have a warrant. They didn't rescue a warrant. They lied and said they had a warrant. And then when she grabbed the warrant to look at it, they, beat her up and took it away from her and handcuffed her and took her away and searched her house. And so they extended the Fourth Amendment to the states. In Mapp v. Ohio, it was official 1961. So that's how long we went where it really wasn't. The Fourth Amendment didn't really apply to the states. As late as 1959, states were doing illegal searches and giving them to the federal government. Well, then they said, well, you can't, we're not going to let these federal cases go forward with illegally obtained evidence from the states. So then you had Mapp v. Ohio. Now that Mapp v. Ohio was something that the police did that was bad. Okay, was not a good day for police. But the next case I want to talk about is Terry v. Ohio. And there was a detective. He had 20-some years of experience. He was watching two people in front of a jewelry store, and he saw some activity that made him suspicious. And these individuals were walking back and forth. They were conversing with one another, looking in this jewelry store, and then would walk away and then would come back and look in the window again and converse a little bit more. And he said, you know what I think is, and I'm going to use a North Carolina term here for anybody from North Carolina, you know what's fixing to happen? They're fixing to rob that place. All right, so they're casing it. And so he based that on his experience. And this is where I used that term earlier, that a similarly trained police officer would recognize as a crime. Well, he had 25 years of experience as a detective, saw this and said, you know what? They're casing that jewelry store. And so he walked up to them, identified himself, and asked them what they were doing, and they mumbled something. And he became suspicious that they were armed, and he threw them against the wall and found a gun in Terry's pocket and arrested. And it went to the Supreme Court, and the Supreme Court, what you can see where the Fourth Amendment's implicated here, right? I'm sure Terry's defense attorney made a great case for, hey, my guy was just walking around hanging out with some friends and he just got accosted by this police officer, right? And the police officer laid out all these facts of things that he saw, and the Supreme Court ultimately ruled that a thing called a stop and frisk, when the officer has reasonable belief that a crime is in progress and the suspects may be armed. So there was the two things. One, he saw what he thought was a jewelry store robbery getting ready to happen. And, you know, he said in his testimony, jewelry store robberies, how are they usually accomplished? With a gun, right? Yeah, with a gun. So the Supreme Court said that's okay. Now that's been extended. We use it for different things now. There's the plain field doctrine. You know, if I'm patting you down for weapons and I feel something I know isn't a weapon, but it's packaged like narcotics are usually packaged, we can use the plain field doctrine to say, you know, because with reasonable suspicion, you don't have a full-blown authority to search. You don't have that full-blown authority to search. You have limited authority to search for weapons. That's what stop and frisk is about. It's about searching for weapons. You have to have some reasonable belief that whatever they're doing may involve weapons. Questions, comments? Does that make sense? Or are you getting like some of my classes and saying, yeah, it doesn't make sense, but I'm not going to stop him here. All right, this is the one I love. Well, I love them all, but Carroll v. U.S. in 1925. What was popular in 1925? What was going on in our country that might lead to a case revolving around a search of an automobile? You're muted, Paul. I think you said something though.
Had something to do with alcohol, didn't it?
It had something to do with alcohol. Moonshine, absolutely. So Carroll was a moonshiner, okay? Carroll was a moonshiner, and he was in violation of federal law. And they knew he was a moonshiner, and they kept trying to catch him, and he kept slipping away. Well, one day, these two enterprising young officers, federal officers, had a chance to stop Carroll, and he hadn't had a chance to get rid of his moonshine. Now, if you can think of what the vehicles looked like in 1925, they don't look like what's parked in my garage right now, right? They had that little, what is it, the little seat in the back, you know, that people sat in the open in the back. So the revenue officers knew that there was moonshine in this vehicle. So they had probable cause. So in Carroll v. U.S., it upheld searches of automobiles without a warrant due to their inherent mobility. Meaning, if I said to you, I pull you over because you're a moonshiner, Paul, and I say, I'm going to go get a warrant. You stay right here, and I drive away. Are you going to be there when I get back with my warrant? Probably not. Not if you're smart, right? Not if you're smart. So they said, you know what? If there's probable cause, we're going to let the officers search because they can't go get a warrant. And remember, you might say, well, why can't they call up and get a warrant? We didn't have cell phones in 1925, right? Now I can call a magistrate, give them probable cause over the phone. They can say, I'm issuing a warrant. I could stand there with you, Paul, wait for the officer to get there with a warrant and say, here's a warrant. But they haven't made us do that yet. So the thing that's funny is you don't realize is he had hidden his alcohol really well in that vehicle. And they used knives to cut up the back seat and other storage areas to locate this alcohol. And they found all the alcohol, arrested him, and left his vehicle sitting there on the side of the road, just completely destroyed. And the Supreme Court said, yeah, there was probable cause. We're not going to upset it. And that's been the law of the land for almost 100 years. And that's been extended to boats, airplanes, helicopters, any type of aircraft, anything that can be moved under Carroll. If I have probable cause, I don't have to go get a warrant. I don't have to go get a warrant. Questions about that, about Carroll? And I still don't have to take my cell phone, call a magistrate and get a warrant. We can still operate under the fact that it's movable. It can get away. All right, any questions about that? No? Okay. All right, so then there's Tennessee v. Garner. Held that any use of force by police officers is a seizure and subject to Fourth Amendment scrutiny. What happened in Tennessee v. Garner? Again, an interesting case to me. In fact, I just taught firearms Saturday, as a matter of fact, in Gates County, North Carolina, to some new officers, or to a new officer and some experienced officers. And we always, every year, we have to go over Tennessee v. Garner, and this case was decided in 1985. And this will tell you how old I am. in 1985, after this case was decided, I'm sorry, 1986, after this case was decided, I had to go through through training because I was a military policeman, and there was held over from the Middle Ages a concept of shooting a fleeing felon. If you suspected a person was a fleeing felon, you could use deadly force to stop them. So and that's what I'm going to talk about Tennessee v. Garner a little bit more detail. So that in 1986, they brought all of us in, and I was in the class, and they said, okay, we used to tell you could shoot fleeing felons, but now with Tennessee v. Garner, you can't. And here's what happened. A neighbor across the street saw what she thought was a break-in at a neighbor's house, and she knew that the neighbors were on vacation and were out of town. So she called the police, and this was in Tennessee, obviously. And Tennessee had a law that basically codified or made law that you could shoot a fleeing felon. And so they were able to shoot fleeing felons, as could many of us across the country back in the 1980s, believe it or not. So they go there, and one of the officers says, I'm going to go around back and see if anything's going on back there. So he goes around back, and about that time, he sees a young man who he estimates is between 14 to 16, and he's got a purse in his hand. So he's broken into a house and stolen a purse. Incidentally, that purse contained $10, just so we know the whole magnitude of this. And the individual starts to run. Now, there are things I always joke that, I'm in my 50s and I'm still a police officer, and a man has got to know his limitations, right? If a 16-year-old runs across the yard and starts to climb a 6-foot fence, what do you all think the chances are that Joe DiStefano is going to run him down, jump that fence, and catch him on the other side of the fence? Yeah, zero to none, and none just left the building, or slim to none and slim just left the building. It's not going to happen. And this officer knew that. He said, he testified, when that guy started running, I knew I was older, not as fit, and he was climbing over that fence. And if he got to the other side, he was going to get away. And so he relied on Tennessee law, which said you can shoot a fleeing felon, break in, larceny. That's burglary. So he fires one shot. He claimed at the time it was a warning shot, but it happened to hit the young man in the neck. Hit him in the neck. Hit Garner in the neck and killed him. And he had $10 in that purse. So the Supreme Court looked at it and said, you know what? Back in the Middle Ages, when we adopted this fleeing felon rule, most felonies carried the death penalty. So the feeling was, you break into somebody's house and you're running away. Back in those days, it carried the death penalty. So if you got killed fleeing, no harm, no foul. We just sped justice up for you, right? Now, that's not a very contemporary belief, but it was, something that was believed hundreds of years ago, and it had carried through until the 80s. They said, the Supreme Court said, no, we're not going to upset that. We're not going to, all uses of force are a seizure. Anytime a police officer uses force, that means when we were attempting to arrest somebody outside of Walgreens this past weekend, and the individual said, F you, I'm out of here, and starts to walk away, and I reached up and grabbed his arm and pulled him back, that's a Fourth Amendment issue, right? That's a use of force by a police officer. I had gone beyond just being present there to grabbing his arm and pulling him back and said, you're not going anywhere, right? So any use of force by the police now is subject to Fourth Amendment scrutiny. That's why I think it's so important, because now he thought his rights were violated. On the other hand, I disagreed, because I'd been informed that Pasquotank County in North Carolina had a warrant of arrest out for him, order for arrest out for him. So I was relying on that and used a minimum amount of force to say, yeah, you're not going anywhere. Now, the sad part is he's a little bit older than me. And when we loaded him up in the vehicle to take him to jail, I had to load up his walker too. So yeah, that's how exciting my life is when I'm down there. All right. Last case I want to talk about on this page is Wren v. United States. Now, a lot of times as a police officer, you might be looking at a vehicle saying, I need to stop that vehicle because something's going on, but you don't know exactly what. that's what we get paid to do, is be suspicious, to be curious, and to see what's going on when we think there might be something amiss. Well, in 1996, some drug officers were patrolling in DC, and they saw a vehicle and it had a taillight out. Now, taillight out is a violation of traffic law, right? Motor vehicle law. Do drug officers enforce motor vehicle law? They do not. And in fact, they testified. We didn't really care about the taillight, but we knew it was a traffic violation, so we stopped the vehicle. And look, here in Suffolk, where I live, a lot of people don't know it, but if you're riding your bike after sunset, you got to have a light. The little white reflector is not okay. I can't tell you how many bikes I stopped for not having a headlight at night because I wanted to search or to see what was going on, because there was something else wrong with what they were doing, but nothing I could put my finger on. But not having a light is a reason to stop. And that's a pretext stop for a traffic violation, while looking for some other crime does not violate the Fourth Amendment, as long as the reason for stop is objectively reasonable. In other words, it is a violation of law. Some legislature somewhere said, you can't do this or you must do this. So if you ride at night in Suffolk and you just have that little white reflector on the front, you can be stopped by the police if they want to look for other crimes. Questions? Sounds kind of underhanded, doesn't it? That the police, a little bit, yeah, just a little bit. But the Supreme Court said, yeah, if there's a law that says you must have have two taillights on the back of your vehicle and you only have one because one of them's out, the narcotics officers can stop you. They don't have to have anything more just to see if you're involved in narcotics. And if you're not, they give you a warning for it and let's send you on your way. All right, any questions?
So wasn't there some psychology that was involved with that? The idea that if you're willing to disregard the large laws, that you'll be certainly willing to disregard the smaller laws, and that's why it's beneficial to pursue some of these smaller crimes. The whole,
you hit on a
Windows
topic
3.
that is near and dear to me. I've preached for years. I'm not familiar with the psychological research on that, but I can tell you that in my 39 years of experience, I have found that if people won't take care of small things like getting their vehicle registered, getting their inspection stickers making sure their inspection stickers up to date, making sure that the lights on their vehicles work, they're apt to not take care of, they're apt to violate bigger laws. And that's what I found in my experience. And that's what I used to, when I was a field training officer, I used to tell my officers, yeah, look for small stuff because it usually leads to big stuff. It usually, if you see a vehicle with an expired inspection sticker, there's probably a reason, because that person doesn't care about, following the law. But you're absolutely right. I'm not familiar with the research, but it has been my experience over the last nearly 40 years that yeah, those little things are indicative normally of bigger things. And the Supreme Court said, yeah, if you want to stop them for for something dangling from their mirror, because it is illegal to hang the air freshener from your mirror, which is why, in fact, I just put an air freshener in today into my car. And it's one of those that you slide open and you put down on the floor because it doesn't obstruct my view at all. So it's down underneath the seat. But yeah, you're absolutely right. It has been my experience. I hesitate to call it research, but it's been something I have found to be true over the last nearly 4 decades of stopping people for various things. Good questions. Anything else? I thought y'all would ask me about Tennessee V Garner, because that was, there are very few people even who I teach today who were law enforcement officers in 1985 and had to be retrained on, okay, don't shoot fleeing felons anymore. I mean, that's basically what it came down to. Is, yeah, we said it was okay. It's not okay anymore. So, all right, there's some exceptions to the Fourth Amendment, and these I'm going to go through because I have about an hour, so we have about 8 more minutes. I'm going to go through these. Search incident to a lawful arrest. So if I place you under arrest because there's an order for arrest from Pasco County, or there's an order of arrest from Virginia and they'll extradite you, and I place you under arrest, I get to search you. Now, some of the confusing things I will tell you is when these little babies became portable. Some of us in here may remember when they weren't portable. They look like a large pocketbook that you put over your shoulder And then I remember my ex-wife got a portable one, which was about that big and had a big old antenna sticking out of the top of it. And that was her portable phone. But as they became more and more portable, but when people started carrying cell phones, we were confronted with something that the law didn't really address. Can I search your cell phone? Incident to lawful arrest. So can I take your cell phone out and start looking at who you've been talking to and what you've been doing? And originally the courts didn't know because the law didn't really address it. Because if it was on your person, and I'll use this analogy, if I arrested you and you had a pack of cigarettes on you, I didn't assume they were cigarettes. I searched it, and frequently I found other drugs inside the pack of cigarettes. And that was considered a lawful search because I had taken you into custody. So that was a legal search and didn't violate the Fourth Amendment because, you know, if I tell you you're under arrest, handcuff you, and then start patting your pockets down, the biggest intrusion was handcuffing you and telling you were going to a magistrate tonight, right? So the court said, yeah, if I go through your cigarettes, it doesn't matter. That's okay. But we ran into some problems because these were often passcode protected and things like that. And where the law is on it now is when I arrest you, I need probable cause to search this. I need probable cause to go into this. Now, if I have probable cause, what can I get? First thing we talked about. Go ahead, Paul. What can I get? I've got you in custody and I take this out of your pocket, but I think that you're doing illegal activity with your phone and I have probable cause. What do I get?
You can get a warrant specifically
I get a warrant
for that data.
Exactly. I get a warrant for your phone. And now theoretically, we can open it even without your permission. And if you think about it, you've probably heard in the news, some terrorist over in California who killed a bunch of people at, I think it was a Christmas party. They had a hard time getting into their iPhone, as a matter of fact, and Apple was reluctant to help them. Well, the Israelis came along with a program that cracked it open and they were able to get in. So there was probable cause, there was a search warrant, and they forced their way into the cell phones. All right, so incident to lawful arrest, we can do a search. Consent. If you consent to be searched, as long as it's knowing and voluntary, it's okay. So if I have no reason to search your home, and we used to call them, they were called knock and talks, and we don't do them so much now because they tend, like anything else, they tended to get abused a little bit. I would walk up and I'd say, hey, Dr. Atkins-Brady, do you mind if I search your house? And you say, sure, no problem. And I have you sign a little document that says I can search your house, and I go in and search, and I find something and I arrest you, then of course you didn't consent then, but I have your signature on a piece of paper. And we actually did that at houses we didn't have probable cause for, but we suspected there was something going on. We would do a knock and talk. And if you have any questions, just feel free to jump in. Otherwise, I'm going to finish you up in time. Open fields. I talked about my friend who owns thousands of acres of land that he leases it to lumber companies to come in and take trees, right? Open fields are not protected by the Fourth Amendment. If you own that much property and it's not the curtilage of your home, there is no reasonable expectation of privacy. So the police can look on it, the police can go on it without a warrant. And it's called the open fields doctrine. Hunters where my friend lives down in Carolina, hunters come on his property all the time to retrieve their dogs and things like that without permission. Questions? Plain view. If the police officer is lawfully where they are and they see something, they don't have to go and get a warrant. They can act on it right away. So police officers walking through the parking lot of the college, and they see they see something that leads them to believe that I'm engaged in illegal activities in my vehicle, they can seize it without going to get a warrant. Because one, Carroll Doctrine. Two, plain view. Same thing, they knock on my door and they see somebody bound and gagged when I open the door on the floor. They don't have to go get a warrant. They can come in because it's immediately obvious that something is going on and they had the right to be at my door. Borders, international airports, and seaports. The borders are protected. If you come in, you are subject to search. You are subject, if you've ever flown in from another country, You're asked all kinds of questions about where you've been, what you've been doing. And there's no Fourth Amendment protections, even for Americans coming back into the US. They can still search you if they feel they want to. Questions? Okay, I talked about this a little bit. Stop and frisk. That is not covered by the Fourth Amendment. That you can be, as long as the officer has reasonable suspicion, they can frisk you for weapons. They can frisk you for weapons. They just have to have reasonable suspicion that you may be armed. I see you unmuted. Did you have a question, Dr. Atkins? Ready?
I do, but you can keep going. It's back on the bullet 3 and 4.
All right, well, let's go back to it. We have a few minutes.
Okay, it's kind of a strange question probably, but
Okay.
Open fields and plain view. It made me wonder about whether or not plain view is only what an officer can see unaided by technology, or for example, are officers permitted to use technology to extend their plain view, like drones? Because what I can see in an open field while I'm standing at the edge is not the same plain view I would have as if I'm flying a drone over your open field.
Okay. And those are two separate things, but plain view, you're absolutely right.
Yeah.
Plain view, the officer has to legally be where they are to see it. And the use of binoculars is okay, but the Supreme Court has said that the use of heat infrared devices to look into a house requires a warrant. So we're going to allow binoculars in open fields. Now, just so you understand open fields, a farmer, that's his property, right? And I have many times, well, several times, we'll just say, gone upon the property of a farmer because there was marijuana being grown illegally there, and spent, 24, 28 hours in that field watching that until I was relieved, and then somebody else came and did it, and then eventually we made the arrest. So open fields doesn't require that I stand at the edge of the field and look in. I can go upon those lands, because if you have, farmland, people go on that property, whether they're supposed to or not, whether you put fences up or not. If you have hundreds of acres, people are going to go on that property. So drones are okay. Infrared devices in aircraft looking down onto your property are okay as well. But if I want to look into your home with infrared devices, I have to have a search warrant, which means I have to have probable cause. I can't just ride through the neighborhood with an infrared device looking at houses. Because what are those good for? It'll detect heat signatures. And now, and if you're going to make a drug case for people who are illegally growing marijuana in their house, a couple of things you look at. They use too much water, they use too much electricity. And when you look at them with an infrared device, there's really hot spots in their house. That really shouldn't be like that. But mainly we look at a house my size uses, say $100 worth of gas every month, but you're down the street not doing anything wrong, but you're using $1,000 every month. That's going to get the attention of law enforcement. But a good question. So plain view is think about a police officer walking through a grocery store and sees something illegal in your purse as you open it up to get your card out or your money to pay. That's plain view, and they don't have to go get a warrant. They can arrest you right there for it. Any other questions before we finish up here? I started about 2 minutes after, so we're doing well. Any other questions? All right, automobiles and other vehicles, don't need to beat that one up. I already talked about that. And exigent or emergencies. The example I have for this one is I knock on a door because we got a complaint about somebody fighting, and I hear somebody inside yell, "Help me," and nobody will come to the door. And that has happened to me here in Suffolk, and that did result in the door being knocked down and us going in. So if somebody says, "Help me," and I can articulate that, that's exigent or emergency situation. Questions? This is a post that's up in my office. I love this, but it's probably inappropriate nowadays, but I still like it. But it is in my office. Now, Dr. Atkins Brady is going to send me an email and tell me to remove that from my office. But it's just something that was given to me back in the 80s and it's Jake Vest. So, any questions? I just loved it the way it said Deputy J. Edgar Bucknuckles interprets the Constitution late one Saturday night on Route 46. Because that's what police officers do, is they have to figure out what these mean and what they're allowed to do based on sometimes quickly evolving situations. Like I said, when I took the guy's driver's license and he said, "Why am I being detained?" I said, "Because I said so." He had aggravated me. I said, "Because I said so." I really didn't. And as I said, I'm going to go. And I said to the other officer, I said, "I'm going to go find out what happened in the store." And the guy says, "Oh, he's doing an investigation. So yeah, he can detain me for that." So it was just funny to me that was the conversation we were having on the side of the road at the Duck Brew in Edenton. But are there any questions? Dr. Atkins Brady, I hope this did what we were intending. I did record it, and I'll get Mark to post it, and so other students and people at the college can look at it if they wish.
Thank you, Mr. I always learn something, so I appreciate you doing it.
All right. Well, next year I plan on doing the 5th and 6th Amendment. So those are the right to an attorney. So we'll talk about those next year. All right. Y'all have a great day, and thanks for coming.
Thank you, sir.
Thank you.
All right, thank you.
If you are a student trying to make sure you get credit, if you will type your name into the chat, I will share it with your instructor, because I assume you're with SDV 100. Is that correct?
Yes.
Okay, if you will type your name into the chat so that I know who to let Miss Stubenrock know who showed up. Okay. Let me see. I'm gonna look at the chat real quick. All right, I got it. Thank you. Take care, Paul.
You too, sir. That was awesome.